So hi everyone, my name is Varduhi. I'm an attorney based out of our Cerritos office. Today, Rajashri, Shalesh, and myself will be doing a presentation how to register a corporation. So a few words about myself. I am originally from Armenia. I moved to the US over 2 years ago. I studied law in Armenia and in London, and now I'm an attorney in California. Whoever knows me probably knows that I love corporate and transactional law, and I'm lucky to be working with Nishita and the team and gain more experience in the US. I hope Raji can share a few words about herself, and then I'll get started on the presentation.
Thanks, Varduhi. Hello, everybody. I know I was on a presentation pretty recently, so with the risk of repetition, I am Rajashri Rajasekharan. I am an attorney at the Santa Clara office. Today, I'll be helping Varduhi with the presentation. Thank you.
Thanks, Reggie. So let's talk about corporations. How to form a corporation. We will mostly be talking about Delaware and California today, but in general, all our states they have specific requirements, but in general, it should be almost the same. So first, what is a corporation? A corporation can be defined as an association of individuals created under authority of law and having a continuous existence independent of the existence of its members. Corporation has powers and liabilities, and both are distinct from those of its members. So, corporation is a separate legal entity. It has separately. It has rights and duties, and it also has separate liability. So, the five basic attributes of a corporation are, as I mentioned, separate legal personality. Management is delegated with the control of a company in the hands of a board of directors. But we will see that the corporation will also have officers. There is shared ownership interests that are tied to retained earnings and assets. So the shareholders do have shared ownership interests. The owners can transfer their interests. So any stockholder can sell their stocks to anyone else. Of course, there can be some restrictions in the bylaws. However, generally that's the case that the stockholder can transfer their interest to anyone outside of the organization. And then the most important attribute is the limited liability. Unlike the sole proprietorship and general partnership, where we will see that the partners or the sole proprietor, they have personal liability, which means if there is a creditor going after this partner, they will be able to recover from their personal assets as well. In case of corporation, the corporation has a limited liability, so the shareholders are protected. Generally, the shareholders will not be liable with their personal assets unless the court decides to pierce the corporate veil. But Raji will talk about it in the end of the presentation. So let's talk about formation. How to form a corporation, what are the key steps and what are the key considerations that we need to think about before forming it. The first major consideration is choosing a jurisdiction for incorporation. The next one is choosing a name. We need to draft articles of incorporation, then bylaws, and drafting a stockholders agreement. From all of these 5 steps, the first 3 are mandatory. The 4th and the 5th one, they are highly recommended, but they are not mandatory. So choosing a jurisdiction. The main thing to consider is where does the corporation plan to do main business. So generally what the corporations do, if let's say I want to form a corporation in a state, the main thing that I need to think about is, okay, where am I going to have my main business? Is it going to be in California? Is it going to be in Nevada or Delaware? And that's where mainly the incorporators or the shareholders, the future shareholders, they think to incorporate the business at. This can avoid the trouble and expense of registering the entity twice, meaning in one state where I just technically register it, but I'm not going to have business in, and then in the state where I'm going to actually do transactions. Many states do not provide an affirmative definition of transacting business. Instead, these states set out certain activities that alone do not constitute transacting business, and accordingly do not require a foreign corporation to obtain a certificate of authority. As a practical matter, if the entity routinely conducts business in more than one state, avoiding double registration may not be possible. So there can be reasons for a corporation, however, to decide and incorporate in our state. Let's say I'm going to do business in California. However, I decide that I'm going to register my corporation in Delaware. What are those considerations that I may give certain thought, and based on that decide that Delaware is a better state in terms of incorporation? The first one is whether the corporation laws are compatible with the goals of the corporation. The second one is the regulatory burdens associated with the jurisdiction. Generally, it is well known that in Delaware, the corporate laws are more flexible. So most corporations, especially the big corporations, they register in Delaware. If I'm not mistaken, about 60% of Fortune 500 companies are incorporated in Delaware. So they have more flexible regulations, and it's not as stringent as in our state. And the main concern is, of course, taxation. So taxation is different in each state. States have different tax rates, and then also different ways of taxation. We all know of this franchise tax that is in probably every state. At least it is in California and Delaware. And just to compare, in Delaware, that have basic franchise tax is $175. Of course, there is a calculation needed there based on the par value and the number of shares. But in California, the minimum is $800. And then finally, one of the major concerns is the courts. Delaware, for example, has a court of chancery. It is a well-known court. It has very experienced, distinguished lawyers, judges who have a vast experience in corporate law. And unlike other states, the Delaware Court of Chancery, they hear corporate matters in a very quick manner, and they do not need a jury. So corporations may want to have this court because they know that whatever issue they are going to have, whatever case they may have, it's going to be resolved pretty fast, unlike in other states. Talk about choosing a name. There are certain naming requirements. First of all, the name must contain words corporation, incorporated, company, limited, or the abbreviations. And this is based on the Model Corporations Code. So the council should always look into the specific state law. The most concerning issue here is that the council should keep an eye on is that the name should be distinguishable. And this is in every state, which means that the name needs to be distinguishable from the corporate name of any business incorporated, from a corporate name that is reserved, maybe not yet incorporated, but still reserved, from a fictitious name adopted by a foreign corporation, and the corporate name of a nonprofit organization. The main concern here is that, of course, the law and the legislature, they don't want to have companies with similar names where the public will get confused. So they want to make sure that the name is distinctive. Let's talk about fictitious name. Fictitious name, unlike the legal name, is not registered with Secretary of State, and we will talk about it in a minute. Fictitious name is the doing business as. I'm sure some of you have seen business name DBA, and that's where we have the fictitious name. Usually the companies may decide that they want to do a business under our name, and that name they will have to register with the county where the principal office is based. They have to file a separate form where they specify the legal name of a corporation and then the fictitious name under which they will be transacting the business. And there is a certain amount of days in California, I think it's 40 or 45 days, that you need to register the fictitious name after transacting business in that county. So what's the process of registering the name? reserving the name. First of all, what I would recommend doing is first check Secretary of State website. Do just simple business search and see if a name is available. Of course, this is going to show just the already incorporated businesses. It's not going to show the reserved names. However, it can still give you information whether that name is taken or not. Next, it will be good to discuss with your client whether you want to reserve a name or not. If a client is really concerned about the name and wants to make sure that the company has this name, you will have to go and file a form and reserve the name. Of course, with service, you will have to pay for it. And I think the reservation in California is going to be for 60 days. So you can reserve that specific name. However, if a client is not very concerned about a name reservation and thinks that, okay, if that name does not work, they can choose some other name, then maybe if you know that you are going to file the articles of incorporation soon, not let's say in a month or so, but soon, you can actually skip this step, reserving the name, and then just go ahead and draft the articles of incorporation and file it with the Secretary of State. So we talked already about the filing a request form to reserve a name, and then finally trademark registration. A corporation may consider to also trademark its name, which will make the name kind of a brand name. And they can, but it's not necessary, it's not required to have a legal name as a trademark name. However, because by law, you can have all like even symbols or other words trademarked. However, if let's say a corporation wants to trademark their name, legal name, they may go and file a separate form with USPTO, the Federal Agency of Patents and Trademarks. Let's talk about drafting and filing articles of incorporation. These are the basic steps that anyone should follow. First, prepare articles of incorporation. We will talk about this in the next slide. But once the articles of incorporation are already prepared, drafted, the incorporators need to sign it. There is no requirement to have more than one incorporator, at least in Delaware and in California. However, if there are multiple incorporators, then all of the incorporators need to execute the articles of incorporation. And then finally, once executed, the articles of incorporation need to be submitted to the Secretary of State, along, of course, paying the filing fee. And generally about the filing fee, just so that you have some kind of, general how much it's going to be. In California, I think it's like $100, and in Delaware, it's $89. Of course, if you want some expedite processing, it's going to add up cost. Next slide, please. So articles of incorporation, okay, what is the information that for sure, by all means, is required by law to be included in the articles, and what some other information an incorporator or the shareholders may decide to include, but it's not a requirement. So information that by all means need to be included is first, the corporate name, and we already talked about it. Next, it's the number of shares the corporation is authorized to issue. The articles must specify not only the number of shares, but also the different classes of shares that may have. So first of all, the various classes of authorized stock, such as common and preferred, and then the number of shares in each class, and then also the privileges, rights, and preferences of each class. The articles of incorporation must also authorize one or more classes of shares that have unlimited voting rights and one or more classes of shares that are entitled to receive the net assets of a corporation upon dissolution. Generally, it would be the common stock. Next, initial registered office and name of registered agent. This is really important in terms of future service on the corporation. So the articles of incorporation must provide the corporation's street address to service of process and for official mailings. Additionally, the articles must provide the name of a registered agent at that office. What many corporations choose to do is they either designate their registered office to be the corporation's principal business office and business offices, and the registered agent to be an officer of a corporation. However, our corporations may appoint their corporate counsel, and we have had clients like that who actually appoint us as their registered agent. And finally, some corporations choose to designate an independent commercial service company as their registered agent. In Delaware, for example, there is a requirement that the registered agent should have a registered address, so in Delaware. So that means that for sure you have to pick a registered agent from Delaware. So, and then finally, the articles of incorporation should also have name and address of each incorporator. So the role of the incorporator is somewhat mechanical. The incorporator is charged with the responsibility of signing the articles of incorporation and ensuring that those are filed with the Secretary of State. And then if articles of incorporation do not name directors of a corporation, the incorporators select the directors at an organizational meeting and then resign. And once the corporation is formed and the board of directors is determined, the incorporator's job is complete. However, it seems that the incorporator's job is relatively simple and with no responsibility or anything like that. But in reality, if an incorporator participates in pre-incorporation transactions, there may be a liability tied with it. If the incorporator is prepared to act on behalf of a corporation before the corporation is legally formed, and the incorporators know that the corporation is not yet formed, they may be held jointly and severally liable for all pre-incorporation liabilities to which they bind the corporation. Now let's talk about what may be included in the articles of incorporation, but generally is not required. Names and addresses of the initial directors. This is generally the information that will be included in the bylaws, and Raji will walk you through it. But some companies, they may opt for having the initial director's names specified in the articles of incorporation. For example, in Delaware, there is the Delaware state generally is very keeping information very private. So if you go on Secretary of State website in California, you will see that information about the corporation. It shows the directors. In Delaware, there is no such thing. Even if the directors do appear in the articles of incorporation, they are not going to appear on Delaware Secretary of State website. Next is the corporation may decide to include in the articles of incorporation the purpose for which the corporation is organized. What we generally see is that the purpose, companies do not actually limit the purpose of a corporation. They just mention that it is formed for any legal purpose. However, the corporation can always opt for and have a limited type of purpose or even a limited time of period that it's going to be in existence. Next is par value for authorized shares. This was in all times, this was actually a requirement, but now it is not required to have a par value. But all corporations, they may opt to have a par value of the shares, and in that case, they may also include that par value in the articles of incorporation. In Delaware, for example, where the articles of incorporation is actually called certificate of incorporation, in the certificate you may want to include the par value of shares, because the tax is going to be calculated based on the number of shares, so based on the value. Having par value may help. Generally, the corporations opt for a very minute amount of par value, such as $0.001 per share. Next is provisions regarding indemnification of a director or officer. This is again something that is generally included in the bylaws. And then finally, any other provisions that you could generally see in bylaws. For example, it could be how to report or records or how frequently to have board meetings, shareholder meetings, and things like that. I'll pass it over to Raji to talk about bylaws.
Thanks, Valduhi. Moving on to the bylaws, I'm sure most of us here have often faced these questions from our India-based clientele. They ask us what the difference between the articles and the bylaws are. And just to give you a little bit of background, back in India, there are two documents, one being the Memorandum of Association, the other being the Articles of Association, which is the equivalent of the bylaws. And both these documents are required by law to be filed with the Ministry of Corporate Affairs. So essentially, back in India, the equivalent of the bylaws is something that's publicly available. So oftentimes we get to tell clients that the bylaws here in the US are completely an internal document, and it is to be maintained internally by the corporation. As to the difference between the articles of incorporation and the bylaws tend to be more detailed. They provide far more greater guidance as to the management and operation of the corporation. They could tell you the manner in which the meetings are to be held and decisions and actions of the corporation are to be taken. Most of the common topics that bylaws cover are, of course, board and shareholder meetings, voting rights and quorum, authorized committees of the board, the limits and the procedures for transfer of ownership interests, and last with the winding up and dissolution. What we do as a common practice with most clients is to customize the bylaws so that it is suitable for their ask. Corporate governance is extremely important, and the customization is something that we offer that vendors outside the firm obviously don't offer. Licenses and permits. This is also a very important part of the incorporation process. Licensing and permit requirements are often classified into federal, state, and local laws. And each of these factors have requirements of their own. And obviously, they differ from one state to another depending on the jurisdiction. But from a bird's eye point of view, most of the general requirements are usually in and around obtaining a general business license, registering with the state's Department of Revenue for taxation purposes, registering with the state's unemployment compensation, or the state's workers' compensation agencies. So essentially, this comes in, this is very important because once the corporation is incorporated, they would like to have employees of their own. And these employees, the taxes or the payroll taxes of these employees would obviously depend on the state in which they perform their employment services, as a result of which these licenses and permits become extremely important. Employer identification number. This is, again, one of the very important steps in an incorporation process. The EIN is essentially the SSN counterpart of a corporation. It is the number by which the IRS identifies a corporation for all of its tax purposes. And there are different ways in which you can obtain an EIN, either by online, mail, or phone. And the form that you'll have to fill is the form SS4. It's a very simple document. It's a one-pager. So the foreign entity qualification. So essentially, every corporation that's registered in that particular state is a domestic corporation as far as that state is concerned. And if that corporation were to conduct business in any other state, then there are legal tax and registration ramifications, as a result of which that corporation would have to get itself qualified in a different state so that the compliance is in place. As far as California is concerned, they apply something called the doing business test, which we've often heard is also known as the nexus test. So what exactly does a corporation have to do in California for it to be foreign qualified as an entity here in California? So merely having a bank account or defending a suit here in California, or getting sales done through independent contractors and not employees. Now, these kind of activities do not trigger the doing business test. the kind of business that you would have to do in California for you to actually qualify as doing business would have to be repeated and successive transactions, so that you would be in compliance when you register as a foreign entity. If not, by looking at the very dollar amount, it's quite a hefty amount. It's going to be $20 for each unauthorized transaction, which of course can rake up to quite an amount if you multiply it with the number of transactions. The foreign qualification process is fairly simple. You'll have to file a statement and designation form with the California Secretary of State. The filing fee is $100, and pre-COVID times, the processing was also really fast. We would have it processed in about 3 business days, but right now it's taking anywhere between 7 and 10 business days. The last topic here is corporate governance. We often have clients that get their corporations incorporated elsewhere, and they get to us, and they come to us when they're faced with disputes. Say, for example, they're not getting along with a shareholder, or they're trying to renegotiate the right of first refusal with a shareholder who's now become having a little bit of animosity towards the person that actually formed the corporation, and so on and so forth. And each time when we actually look at the background and the history to these disputes, most often than not, we find that their corporate governance has not been on point. So it's extremely important to follow the terms and conditions that have been laid down in the bylaws. And the first step towards this, right after the incorporation, would be to have an organizational meeting. And at this meeting, officers are appointed, the bylaws are adopted, and there's a resolution that's passed by the corporation so that the corporation can open bank accounts, as well as the initial inceptional matters are discussed. Coming back to the importance of maintaining corporate formalities, all of us know that a corporation is a very unique theory of law, meaning to say that it has an existence of its own that's completely independent and autonomous of the existence of the people that manage and operate the day-to-day activities of that corporation. And here is where the question of piercing the corporate wheel happens. So when there's not proper corporate governance, then it's always easy for people that are having disputes with the corporation, most likely, disgruntled shareholders or creditors, to come back and say, no, that we've got to pierce the corporate wheel because the people associated with the corporation have been dealing with it like it's their own company, commingling funds or undercapitalization of the corporation, and not maintaining corporate formalities is one of the main factors why we see the piercing of the corporate wheel. Which would then again bring down personal liability and responsibility for the debts and obligations onto the officers as regards the creditors and other third parties. Well, that brings us to the close of this session. Thank you so much, everybody, for giving us your time. Thank you so much. Have a great day.